The abuse of language in this whole thing has been horrendous. The use of language assumes a conclusion.
There's always a conclusion assumed to some extent in a court case. An indictment isn't brought in neutrality. Obviously, there's going to be an assumed, I think this person's committed a crime, right? The whole reason why a prosecution brings criminal charges to somebody is they think they can prove it beyond a reasonable doubt, or at least get a plea out of it, right?
How easy it is to get an indictment from a grand jury.
What, reasonable suspicion?
The number of times that a grand jury has not followed a prosecutor's advice to indict somebody can be counted on one hand, of fingers of one hand.
Wait, what? So what do you think that means?
That means that if a prosecutor wants to indict you, the prosecutor can get the grand jury to indict you.
I think you're putting the cart before the horse there?
Just a second. You know how the grand jury works? I won a case in which a grand jury refused to indict my client because I made a motion to the judge who's in charge of the